Estate planning for blended families? Now that's an important conversation to have. Today, I'm privileged to have on our podcast Haans Mulder of Cunningham Dalman here in West Michigan. Haans has a great deal of experience in this area, and in addition to his law degree, holds a Master in Sciences in Taxation, an MBA, and is a certified financial planner. I know you're going to really appreciate the topics we discuss as we just scratch the surface on what you need to be thinking about if you are involved with a blended family.
Welcome to the Navigating Abundance podcast. Our goal is to encourage you to pursue your total family wealth potential through insightful conversation with experts and thought leaders in their fields. But first, some obligatory disclosures. Navigating Abundance podcasts do not represent investment, legal, or tax advice. Any opinion expressed in Navigating Abundance podcast is solely those of Christopher Tanke and his guests and are based upon information believed to be reliable but not guaranteed. Podcasts are produced for educational and entertainment purposes only and should not be considered an endorsement of the guest or the views that they hold. Information shared may not be appropriate for your personal situation. Consult a qualified advisor for guidance. Investment advisory services are offered through Strategic Financial Group, LLC, a registered investment advisor. Navigating Abundance is a trademark of Strategic Financial Group, LLC. And now here's your host, Chris Tanke.
Welcome back to Navigating Abundance. I'm Chris Tanke. On today's podcast, I'm delighted to have Haans Mulder of Cunningham Dalman here in Western Michigan, attorneys at law. We're going to be talking about a topic that I think a lot of you are really going to want to pay attention to, and that is estate planning for blended families. Estate planning for blended families. There are a lot of considerations to consider if you're involved with a second or third marriage, or what might be the case, especially if there are children involved. Haans wrote an article on this very topic here in January of this year, and I read it and I said, not only do I know Haans on a personal level, I know that that article will be really helpful to people. So I took him out to lunch and paid for the whole thing and convinced him to come on and share with us a little bit of how he would coach folks if they're facing a blended families and trying to figure out their estate plan. So thank you so much, Counselor, for joining with us today.
Thanks, Chris. Appreciate the opportunity to help.
Obviously, there could be 20 to 30 volumes written on this topic, and we only have 30 minutes or so. So I thought I'd kind of separate our conversation by raising the need and then answering the need, the challenge, and then the solutions. So I'm going to jump into this right now. The challenge is, and I'm quoting from your article, blended families almost always have more complicated dynamics, especially if there are children on one or both sides. So let's talk about the challenge, maybe even bring up some things that people might not even be considering if they find themselves in a blended family situation and they're trying to figure out how their estate plan is going to unfold. How would you just begin to advise people about some things to think about?
Yeah, Chris, as you said, blended families are inherently complicated. I think really when you get down to what's going on, there are really two families that are coming together, right? You have, one family that's existed, and now because of the marriage or the relationship, now there are two families that are coming together. So you've got issues with relationships that we'll talk a lot about, right? And then also issues with resources. So those are really kind of the two buckets that I find they're challenging issues that come up, but also hopefully solutions that we can. And I'll just start with, if that's right, one issue that I see that would come up if I'm pretty early on in advising a client through a blended family. And it's actually kind of an emerging issue in that some clients are, rather than getting married in a legal way, are choosing to have a covenant marriage. So they're getting married with their pastor or priest, but not legally. And sometimes they're doing that by virtue of they don't want to complicate their lives legally, more so due to the nature of a legal marriage. So I've been seeing that more and more over the last number of years, and we can talk about that in more depth. But that's an issue that sometimes I find clients will go down that path of let's be in relationship together. Let's do it in a contractual way and obviously a faith and spiritual way, but not from a legal standpoint.
Now, that's something I didn't even think we'd be covering. Now, see, folks, this is why you have to tune in. some of you are you're in that situation, and that's a very valuable thing to consider. I'm thinking more in line of, although I do want to come back to that, the proverbial gee whiz. I built my estate. I'm going to get married. My spouse has children. I have children. How do we handle this? Do the funds follow the history, the bloodline, the children? Or we've all heard stories of where it actually didn't, and the one that had the assets passed, and things were split equally between their kids and the children of the surviving spouse. And that really wasn't the intent. They wanted to make some provision, but most of their stuff, they wanted to go to their kids. But again, they didn't pay attention to making provision for that. I mean, that's like probably the classic example of a blended family problem for sure. But I am really curious. Let me come back to this spiritual marriage. Are the laws significantly different in that situation? Does this become like a common law situation, maybe even sooner, if there's that kind of a covenant made and that can be proven?
Yeah. So unlike other states, Michigan does not have common law marriage. So a couple that is together but not legally doesn't raise the risk of being characterized as married. And the differences are quite a few, but just to hit on the top ones that I see. One is that the marriage will bring certain requirements that if you have in a estate plan, or as we're talking about, issues like these where somebody has a trust, they have a will, if you haven't addressed the rights of your spouse. So in other words, I think kind of to your point a little bit ago, you're just going to kind of have your estate plan and then that plays out the way it was before the relationship, meaning everything goes to your kids. That will not be the case when you're married, because in Michigan, like a lot of states, they assume or want to protect your spouse from being left out of your estate plan, right? And being disinherited. So there are certain rights by virtue of it, inheritance and allowances that a surviving spouse has. So inherently, there are things that when you get married, you've got to address, or really should address with your estate plan to say, oh, our asset's going to be going to my spouse, or if not, you need that spouse to waive those rights. I tend to see with my practice, blended families coming together in retirement. And at that point, they hopefully don't have health issues, but they're more at risk, right, of health issues that may lead to expensive care somewhere, assisted living or nursing home. And one of the probably the most complicated issues I see when clients are married, and especially when it's a blended family here, is that if one of them needs care in a facility and they start looking at whether Medicaid benefits could be applied for and approved, that marriage is going to require all the assets of the couple. So both the spouse who needs those assets, but also his or her husband or wife. And in doing so, all of what maybe that couple intended to keep separate, now they're in a position where Medicaid requires those assets to be looked at and treated together. And with the cost of nursing home care, probably, in the $12,000 to $13,000 plus a month, that gives some clients pause to try to think through how do we navigate a scenario that we may face if we're married and we have our assets now considered together.
So it's a living estate problem, right? So
right.
Exactly right. But the consequences are quite similar, right? Again, if the assets, most of the assets are on one side, and my spouse, the one that didn't have as many assets, he or she goes into care, and I love them, and we're spending $150,000 a year or whatever, $250,000 a year for a really nice place. That's fine. But in the end, there's going to be less to give to your kids, which is part of the deal. Have you thought through that? Have you discussed that? Right. And if you've discussed it, have you made your wishes known, and have you codified them by some legal work? Right. Because otherwise it's just a well-intentioned. And these are the kind of things that you just have to talk about. And there are no right and wrong answers. They're just your answers. But you have to think about a lot of scenarios here that would affect the fact that you've got a second start here, and there are new dynamics for sure.
There are definitely situations that I've seen where, as you I think pointed out at the beginning of the podcast, people don't plan, but even when they do, how it plays out and creates complications. So one issue that I've seen is it's very common to have the assets go to the surviving spouse, right? That's just the nature of when we're married, we want that to happen. And I'd say absent either assets with very high net worths, right? Who can say, I'm comfortable leaving X amount to my spouse in trust, and then the other assets can go to my kids. A lot of clients really need to, by virtue of their resources, leave everything to their surviving spouse. But as that happens, setting it up in such a way that it's used as they both intended, and then also it's eventually left to who they all agreed it would be left. So one issue that I've unfortunately seen some significant challenges is that surviving spouse all of a sudden reverts back to maybe life patterns or financial decisions that they had before they were married, and the kids of that deceased spouse now see what they perceive to be their future inheritance being diminished at a much faster clip than if their dad or mom were living. So how those assets are passed along. Is that spouse the sole one in charge of spending those assets, maybe as the sole trustee? I'm sure we'll talk more about that. But then on the flip side, I've also seen situations where clients said, okay, if my wife survives, she's going to be a co-trustee with my son. And those relationships weren't healthy. And so when he passed and she survived, it just became a very, unfortunately, toxic relationship in terms of how she wanted to move ahead, and then how her son, felt was appropriate. So that can be unfortunately a real minefield, if you will, for people to navigate. And then you've got, which I'm sure we'll get into more later, but you've got the nature of, okay, if assets are left to that spouse, what ability do they have to direct them in a different way than their deceased spouse thought, right? It's the idea of kind of how is an estate plan locked in where it's going to go to the same people this couple originally planned, or is it different?
As you're talking this through, I'm thinking anything that you can do while you're alive to make your intentions pretty solid, as solid as you can, you're doing your spouse, you're doing your beneficiaries a tremendous favor. Because if again, with Hans, your illustration, if we've got the son of the person who passed at a disagreement with the surviving spouse, or is concerned about the surviving spouse throwing money off the train to her children, this creates a problem. So this is where trust work and thinking through maybe even independent trustees or whatever that case might be, to speak with counsel that you have and to make sure that they understand the dynamics you're looking for and what you'd like to have accomplished, and see if you can't get some of that written down through trust work, make the intentions known, make it as airtight as you can, so that your wishes, I'm going to say, will mostly be realized. They're not always realized, but they'll mostly be realized that way. So some of the common solutions that you brought to this in your article, Hans, was trust work, the idea of doing a joint trust, 2 individual trusts, and the proverbial prenup marital arrangements. So let's jump in. Do you want to talk about joint trusts first, how that might solve some of these problems ahead of time as we're discussing, or do you want to talk about the 2 trusts?
Yeah, why don't we talk about the joint trust? That is oftentimes what I'll talk with clients first about.
All right, so here we are. We're jumping into the situation, Mr. and Mrs. Smith, and we've got some interesting family dynamics. In general, how would you coach us if we're thinking about how to solve for some of these things before the need arises? In other words, while we're both in here in agreement, or frankly, gee whiz, you might You might have one of the spouse say, I can't be in agreement here, but it's my money and this is how I want to do it, right? So how do you coach using joint trusts?
Yeah, so a joint trust can be very helpful for the family to, number one, keep the assets out of probate court. And probate, I think, is an issue that really all clients are thinking about, but I think it's especially important to blended families because if assets go through probate, the law is going to require that all of the interested parties, which can often entail kids that don't get along or may have difficult relationships, they get a lot of disclosure and information and frankly opportunities to maybe raise issues and really make the process much harder than it would be. So I think by its nature, a joint trust, is a really helpful way to make sure that we can keep things out of probate and then ideally avoid the inherent sort of questions, conflicts, and issues like that come up when all of a sudden court is involved with it. So that's oftentimes where I'm kind of starting my counseling with clients. We then talk about the nature of a joint trust around the idea that they're both setting it up, they're both going to benefit from it, and it wouldn't necessarily require that they commingle their assets right away. I have a lot of clients who maybe it's even like the home and the husband or wife's name, and then it maybe goes to the trust at the owner's death, or they keep bank account in their own name and then maybe have the trust as the beneficiary. So it's not so much about like commingling assets right from the beginning, but I think it's more about the nature of wanting to keep things as simple as they can. So not introducing multiple trusts, but then also the idea that if one of the spouses passes, you don't have to have all the assets, but likely all or most of all the assets stay in trust for that surviving spouse and do so in a way that may not involve having to get a tax ID number, filing a tax return, things that for some people it makes sense to have because of their resources. But for most people, we try not to introduce more complexity and additional kind of responsibilities unless it makes sense. So a joint trust can really kind of continue on for that surviving spouse, now using his or her social security number and add a lot. But I would say that probably one of the most fundamental issues to kind of talk through and think through with clients is the idea that if one of them passes, or even frankly maybe is disabled, a joint trust has to speak to how the trust can be changed, if at all. And that, I think you were alluding to a little bit ago, is really kind of a difficult issue because number one, I think clients don't want to think that their spouse is going to do something, right, that is contrary to their marriage and their agreement. But I would say it could be either that surviving spouse all of a sudden meets someone new, and that new relationship can put a lot of pressure and stress on, we want to do all these fun things. I've got now kids that need financial support. You've got resources, how are those resources now? Can we use those to benefit us? Can they use those to benefit our kids? So that, and then how the assets could end up going to someone else. A joint trust can be left completely amendable and revocable. Like that would be the nature of like a first marriage joint trust. I have a couple times over 26 years completely locked in and made a irrevocable trust, or made a joint trust irrevocable at the first spouse's death. But I would say that's definitely not my preference because it, being a planner and trying to help clients with situations that I'm sure you see it in your practice too, where the situations that you thought of in 2026 are not the ones that exist in 2030 or 2035. Having some flexibility to change the trust, but do so in a way that keeps everybody accountable, ideally is most helpful. So what I've found to be a helpful tool to do that is that surviving spouse can change the trust, but with the consent of the successor trustees. So, those trustees are likely going to be people that represent each side of the family. Like, the husband has a child, oftentimes, who's a trustee. That wife will have a child who is also maybe a trustee together. The surviving spouse is really then realizing, okay, I've given up some autonomy here, right? I can't change this trust, but I can go to children, whether it's my child and a stepchild who ideally you trust in general, but also you feel like is going to look out for the whole of the blended families and allow changes that make sense and not allow things that were contrary to the relationship. So that can be a good way, in my experience, of kind of blending the need to change the trust if need be, but not do it in a way that's going to circumvent the kind of the intent of what they start with.
Let me just throw this out there. If you're in a blended family situation and there might be disagreement between you and your spouse, you have some concerns about your spouse's kids or whatever, is the two trust solution a little more airtight? Can you solve for some of these things if you have your own trust and your assets are there and you're saying here's how it will be doled out in the end if I'm no longer here? Does that give you more control in that kind of a situation? Because I imagine having a joint trust, there's a lot of commingling of opinions even in all of that, depending how it's written. But if you have your own trust, you can be a little more proactive to say, no, this is exactly how I want it to work. Is that generally true or not?
I do think each spouse having their own trust definitely gives each more control over the outcome in terms of where the assets go and who they benefit. So having separate trusts can be a really beneficial way to look at it. The separate trusts come though with still some inherent challenges a little bit. One is that if a spouse passes away, I think you've brought it up a couple times too, is that you have to have a trustee of that trust. And, you could say, I want to maybe leave half of my assets to my wife, half of my assets to my kids. But the nature of the portion left to my wife, if she's the sole trustee, there is legal accountability there, but maybe not practical accountability in terms of making sure that those assets are going to actually be used consistent with the terms of the trust. So having even separate trusts does leave open the possibility that if, assuming they're going to be left or some portion is going to be left to a surviving spouse, what's kind of the nature of how that trust works, who's in charge of it, and making sure that the monies in that trust actually get used in a way that, that's consistent with the terms of it. So, a separate trust can kind of lock in and prevent that trust from being changed in the future. But I would say the other somewhat practical issues around like whatever's left to that surviving spouse in trust, still having to think through how to best give that spouse what he or she needs, but realizing that there's got to be thought given to kind of how that's done, who's in charge of it, and who's involved with it. So it's be done consistent with what the spouse's trust said from the beginning.
We just bought a Volvo. Never had a Volvo before. Nice car. And, the one thing you recognize after you write the big check is that I have to have a really good service relationship with the dealership or an independent dealer that really knows Volvos, because these cars can be temperamental and expensive to fix. So it's not about having the car. I have to make sure, how am I going to make sure that, I'm living with this car, that it does what I want it to do? I think this is very much like what you're describing. It's lovely that you have a beautifully written trust. Okay, that's fine. But if you're not here, who's servicing it? Who's going to make sure that what you intend to have happen is going to happen? And, God forbid there's a challenge to it. How can you make sure that those that are trying to change it don't have near the opportunity for success because it was written well and there's a team of people vis-a-vis trustees that are overseeing it that are really have fidelity to you. I just think that these things can unwind just because they're on paper doesn't mean that they're going to be clean. So think in terms of who's going to service the Volvo. Is that fair?
Yeah, that's a great analogy. I think that you don't want to really just kind of walk away from a lawyer's office or a car dealership thinking, right, you've got title.
Yeah.
Everything's going to be fine, because there are going to be issues that come up. And who do you have there to be able to either help you through that process or to, I don't think we oftentimes in this day and age like to think of accountability, but right, how is there going to be accountability and kind of assurance around what you've done, so it's carried out well. Maybe somebody who's going to check in with you on your Volvo to see, like, hey, have you serviced it as we told you, right?
Absolutely right. Just trust is a living, breathing document, unless it's an irrevocable trust. But right, so yeah, it's really only as good as the team of people that are around you, I would say, because we've all seen bad things happen to good people that have trusts that are outdated or that weren't well written or well represented. Just part of the deal. So I think obviously the first step is you're talking it over. Hopefully you can come to agreement with your spouse saying, okay, here's your assets, here are my assets. How much do we commingle for beneficiary's sake? How much do we use for, medical expenses? Should we be saving the cottage that my grandfather built with his bare hands for my kids only, and having these kind of conversations? But then once you have that, you need to codify them in some trust work, joint or independent, and make it as tight as you can. And I hope you can, as a couple, you can see what everybody's doing, so there's no misunderstanding. And then you have good people to service that or represent you when it comes time to meet it out. Because controlling assets from the grave, if that's your intent, it can be expensive and can be problematic. It just is not always simple. If your trust just kind of like empties out within a year or whatever, that's fine. But you have to think in terms of what are you trying to accomplish? What's the end game? And who is going to be there to make sure you get over the goal line you want to go when you're no longer here? That's very important. So it's not just about buying the Volvo, right? Let's talk about prenups, which people just have a negative opinion on. I used to have a real negative opinion on them, and I have been converted. Talk about prenups and how that might be another tool in your tool chest if you're trying to figure out blended families and succession and estate wishes through a blended family situation.
Yeah, we've in part tried to make it a little bit easier for our clients, and that we oftentimes refer to them now as like a premarital agreement. So I think that
sounds better.
Yeah, right. Sometimes the names we give to things, right, immediately turn them off.
It's not a prenup, it's a premarital agreement. Well, we're going to agree. I like it.
That's right.
Okay.
Yeah, and I find the vast majority of my clients who are doing premarital agreements or prenuptial agreements are really doing that to really kind of lock in what their intentions are with their estate plan. We've talked about the idea of, if you have a joint trust, if you have separate trusts, what do you intend to happen with your assets? One issue I'll mention now, and we can get into it in more depth, is especially the nature of what about the house that they live in, right? Because almost inevitably you're going to have a couple that's going from either two houses to one, or one house that the couple or that one person lived in has to benefit two people. So the agreement really encapsulates and addresses all the estate planning issues, in addition to like a trust and wills, powers of attorney, but it makes it a contract, right? Something that you both have to agree to and abide by. So it really kind of puts it in writing and but then the other thing that's always the most awkward issue, right? If this marriage, especially at the point in time that clients are getting married, doesn't work out, then those assets that they're bringing in the marriage, there's a high chance that a court is going to enforce the agreement and leave those separate assets his or her own. I think I mentioned this a little bit ago, that most clients who I'm working with on these issues are either at retirement or in retirement. So they don't have the possibility of working and kind of reestablishing their financial position if they go through a divorce. So they really want to just be good stewards of what they have, right? And make sure either for themselves or for their kids they're not in a situation where, you know, they felt called to get married, but then that marriage does not work, goes through a divorce in 5 years. And now all of a sudden they're left with half of what they came into to the marriage with. And then what are they going to do at age 75 or that late in life? So I think people probably have an appropriate kind of expectation of, they really believe clearly that this marriage is going to work, but they also, don't have, maybe this unrealistic expectation. There's no risk around it. And, they can, just start all over financially and kind of regain that, those assets that they had before. So I think that helps maybe make it a little bit more palatable or easier for them to realize an agreement like this is helpful late in life.
Yeah, and I think the more you communicate, the better off you're going to be. And this is just a formal way of communicating. Of course, that will come about after a lot of discussion privately. Then you sit down with counsel and saying, here's our situation. Here's what we're thinking. Are we thinking right if we want it to go this way? And counsel might come up with another solution that's even better. That's great. I think the bottom line to all of this would be is for any situation, but in particular, if you're in a blended family, you don't want to go to, lawyer.com and, have an 800 number relationship with somebody out there. It just does not work. You need somebody that has boot on the grounds, that you can establish a rapport with, that can hear you, that you are being heard, that is listening to what you're saying, didn't just get their law degree, and they have experience and can talk you through some of these things, because it's complicated. We are just scratching the surface on all of this, and hopefully you're picking up that every situation's a bit different, and you're going to have to sit down and talk it through with somebody that has the experience and the breadth of understanding to give you advice. So that would be my recommendation is, don't go cheap on 1-800-lawyer. Deal with somebody that you can actually sit down with, have a cup of coffee with, that you respect and appreciate, and spend some money and do it right. An ounce of prevention is worth a pound of cure. Words were never truer than in dealing with estate planning for blended families. Would you not agree, counselor? Is that a shameless plug for dealing with a local mom and pop attorney?
I couldn't agree more. I mean, I think these issues are really complicated, and, doing something, either on your own or with someone who's not experienced with it is really fraught with problems. So I think, ideally someone has had a relationship with an estate planning attorney who they trust. But if they don't, it's important to have somebody who, can help them with those issues, but also somebody who has experience and can help navigate all of what we've talked about today, where, you're layering on a whole different set of issues now by virtue of the blended family that you need somebody to advise you on, whether it's legal, some of these issues cross over into tax issues. They get into long-term care. So having somebody that can really walk you through. And my perspective is really to do this in a way that, that obviously I'm representing my client, but also kind of honors the relationship and what they want to accomplish. So not a kind of look, we're going to advocate for every last dollar and try to make this an adversarial process. We want to make it, to the extent it can be, more collaborative, but realizing that there are complicated issues that sometimes are going to benefit one person or another. And you just, to your point, have good communication, and hopefully the parties can work through everything in a way that makes it more likely that this relationship is going to work well and the plan's going to be carried out.
Yeah, that's so true. And I would imagine that you do a lot of marital counseling right there in your office. And I think that's what wise counsel will do. And, sometimes somebody needs to hear, hey, this is a hill you can die on, but I don't think it's worth it. Maybe you should lighten up on that. It's difficult to control. I say the term I use is control assets from the grave anyway. It's very difficult to do it. But maybe there's some things that you can give up now and compromise on, and yet have the majority of what you want to do, come through. Maybe the surviving spouse and their kids, the way this is written, doesn't inherit anything as far as the corpus. But while, you're alive, he's going to do, after you're gone, he's going to do really well, right? By just living off the dividends and the interest and the royalties or whatever. And in the end, they get whatever, 20% of, I don't know. You can build it any way you want, but it does start with communication. And it all starts with a mediator in some ways. If you're not on the same page, to sit down with counsel and talk through some of these things so that you can give your best effort to a successful handoff. Because in the end, none of us stay around forever, right?
That's right.
I like it. Do you have any closing remarks, comments, or anything for us, Haans? I think this has been really good to scratch the surface. Anything that you said, boy, we really should talk about that just for a little bit? Or do we get it all?
I think we have covered some really important issues. And I think to kind of what we've talked about before about you want to work with somebody that you trust and has the expertise, with these issues. And I appreciate you really raising these issues because it's not just a legal issue, right? It's very much issues that involve other advisors like yourself, a CPA. So, bringing in those other advisors on these issues so that all of us can really think through what's going to be the best outcome for the client from a legal, financial, investment, and tax perspective, I think is really important. And I think we say this a lot, but it is, I think, really important here that by being as proactive as you can, I mean, I think that is going to be a much better result than bringing these issues up when all of a sudden there are, broken relationships or, fighting between the couple. Very unlikely to kind of work through anything that's going to be helpful in the end, right? If you do this too late in the process. So I think being proactive is key, and hopefully, all of what we've spoken about with being a good communicator, almost thinking of this as there's going to be some sort of, mediation or exchange of kind of what everybody's going to agree on, doing that at a time where everybody's comfortable. There's a high level of trust is just going to yield the best result.
For sure. When I was in seminary, I was taught that a mist in the pulpit ends up being a fog in the pews. So if I'm going to communicate a message on Sunday morning, it better be clear, concise, easy to understand, powerful. I can't pontificate on things that aren't crystal. Otherwise, people aren't going to understand anything that I'm saying. And again, if you can sit down and craft your sermon, right, with your counsel and have agreement on it, it stands a much better chance of your intentions being fulfilled versus if you're no longer here, one spouse is left and everybody's trying to patch it up from here, trying to figure out what you meant, or, well, that's what he said, but maybe that's not even what he meant, and all that kind of stuff. No. Get it down, crystal, as clear as you can while you're alive, right? And deal with folks that not only, if they sell you the Volvo, can service the Volvo too. I think that would be my advice as a novice in this area. Haans, thank you so much for giving us some of your valuable time today. Really appreciate you, my friend. If people want to contact you, are you interested in gaining new clients or not?
Yeah, I'd be glad to help folks. I'm sure, like you share too, one of the joys of this practice, right, is helping people and helping new people as they have issues come up. Appreciate the education you're doing and getting really the issues out there that people may not be aware of, or if they are learning something, hopefully that they can. Thank
you very much, folks. We just want you not to hesitate and procrastinate. We want you to move. And if there's any way that this sparks some interest in this, please run with it, because mañana is disaster in a blended family. That's for sure. So again, thank you so much, Haans. We will put contact information up here on the screen and also on our show notes for you if you want to get a hold of Haans and his team. But in the meantime, we appreciate you, my friend. Thank you so much. And folks, I just want to encourage you, although sometimes these conversations can be difficult, as we say all the time, your family is worth it.
Thank you for joining us for today's episode of Navigating Abundance. If you enjoyed this content and you'd like to see more of it in the future, please consider subscribing. If you'd like to join the conversation, leave a comment below on whatever platform that you're watching on. And if you'd like to learn more about Navigating Abundance, visit us at navigatingabundance.com.